Okay, good morning, everybody. So I'm delighted to be here to talk about one of my favorite topics, good contracts, more than just a handshake. And I'll tell you a little bit about myself. I have a law practice as a business and employment attorney, so I deal with contracts from that perspective. But I'm also a mediator and arbitrator. And so I help parties resolve disputes, often arising out of contracts. And so I can see what kinds of things go wrong with them. And something else that I do is that I teach at Toro Law School. And I was telling Bill this morning, one of the classes I teach is interviewing, negotiating, and counseling, which is not about the substantive topic of contracts, but really about the process of kind of getting there to make sure that you have the facts, advising your counsel, and negotiations. So I'm really delighted to be here, and let's just get started. I should also say I see a couple of familiar names among the participants, and I'm delighted to see them. So let's start out with, why should you have your contracts in writing? So actually, New York and other states and the federal government have some requirements as to what kinds of contracts should be in writing. For example, the New York Statute of Frauds lists certain kinds of contracts, such as real estate or business brokerage agreements, that should be in writing. And but on the employment side, for example, employers are required to give employees written notices of pay. What is their salary? What are their tips? How is their compensation calculated? So there are some requirements. However, I want to share my view that it's always a good idea to get it in writing for several reasons. Number one, you wouldn't build a house without blueprints. So most contracts these days in the information and technology economy are not just somebody selling a chair to somebody else, which is a simple transaction, but people and companies are providing services, or they're providing a combination of goods and services. So contracts provide good blueprints for business transactions and relationships. The contracting process is actually important for the parties to clarify and confirm their obligations. I was drafting an employment contract this week, and one of the parties gave me instructions as to what the terms were going to be. And the other party said, no, those, and so I drafted it that way. And the other party said, oh, no, that's not what I intended. And so they had to hash it out between themselves and finally agree on what the contract terms were. And then I was really able to draft them. Another reason to have contracts in writing is to create institutional memory. Some of us have our own businesses, but we do business with large organizations. In those large organizations, people change jobs, responsibilities get shifted around, and all of a sudden you're dealing with somebody other than the person you dealt with when you entered into the contract. Therefore, it's very important that there be a record of what's agreed to, because you may be dealing with somebody who wasn't there when the contract was negotiated. And finally, and this is very important, and I see this all the time as a mediator and arbitrator, other people who are strangers to this deal have to read and understand and interpret the contract. That could be judges, juries, an arbitrator, or a mediator. And if your contract is not clear and in writing, then you're going to have at that point a dispute about not only are the parties in compliance, but what the contract was in the first place. So I'm going to assume that most of you on the call are small business owners. So you might ask, what written contracts do I need? Well, one of the most important thing, if you are not going into business on your own, but have business partners, is that you must have whatever the applicable form of business partnership agreement is required. If you have a corporation, that would be a shareholder agreement. If you have a limited liability company, that would be an operating agreement. If you have an old-fashioned partnership, that would be a partnership agreement. And the issues that need to be addressed in that business partnership agreement are: who has what responsibilities? How will decisions be made? What are the financial burdens on the participants? What are their rights? And most importantly, how are they going to get out of this deal if it goes bad? And I refer to that as graceful exit provisions. Can one party buy out the other? Will they agree to dissolve the partnership? Another type of agreement that's very important are employee agreements. And not only should they cover the rate of pay, but whether the contract is at will or for a definite time, and especially if the employee is doing any kind of creative work for you, who owns the intellectual property that they might create, and also how are you going to protect your own company's intellectual property? And that could be your trade secrets, your customer lists, your supplier lists. And there are ways to protect those important assets in your employee agreements. Another kind of agreement that's very important to get in writing is consulting agreements. A lot of contract disputes arise out of these. And people might think that, well, it's very similar to an employee agreement, but actually the allocation of intellectual property rights, for example, is very different in a consulting context versus an employee context. And also, if somebody is doing work for you as a consultant, you want to make sure that if the Department of Labor or anybody else challenges that characterization, that you include in your agreement those factors that justify the person being deemed a consultant. For example, they control how the work is done, where it's done, when it's done. They probably provide their own computer or other items used in performing the work. Another kind of agreement that's very important are agreements with your suppliers. And finally, any kind of real estate related agreements, especially leases. So once you've committed to getting your agreement in writing, let's talk about the kinds of topics that should be covered in your agreement. So the first is, who are the parties? Well, this sounds simple enough. However, it's very important to keep in mind that if you are doing business through a corporation or a limited liability company, from the perspective of the law, those are actually separate legal people. And if you want to have the protection from liability that the law provides for doing business under the auspices of a business entity, then you need to absolutely make it clear to anybody you're contracting with that it is your company and not you personally who is the contracting party. And so you should list your full company name, including the reference to Inc. or corporation or LLC. And also, I sometimes see sort of confusing situations. I just saw one yesterday where the contracting party, the customer, was one entity, and it involved a monthly charge, but the authorization for withdrawals from the bank to make payments were under the name of a different entity. And if you see something like that, that's kind of a red flag, because not only should you and the other party be very clear that it's an entity that's doing business, but which entity it is. Sometimes people own multiple entities and they do not pay attention to the corporate formalities, and they, share resources or funds between those entities, and there you lose the benefit again of doing business as a corporation. But whether you're the contracting party or you're looking at who you're contracting with, you want to be absolutely certain as to who is the entity you're doing business with. So once you've determined who that is, and by the way, I should mention this. I don't know that anybody did. If you have any questions as I'm going along, it would be my preference that you post them in the chat. And when I'm finished with my presentation, I'll be happy to address them. So I'm sorry I didn't mention that earlier. But anyway, back to the topic of what should be covered in your contract. The most important thing is, what are the parties' respective responsibilities? And as I said, this should really look like a blueprint or a project plan, really laying out what is everybody going to do. And one thing, if you are the business and providing services to a customer, it's very important to remember that customers usually have responsibilities also. For example, if your customer is going to have to provide certain information to you for you to do your job properly, then that should be included in your agreement. If they're going to have to provide access to their facility, that should be laid out too. If their personnel are going to cooperate, then who is it that's the liaison and who will be performing those responsibilities? So it should be like a project plan. Anybody should be able to look at it and see what's going to be done and by whom. Then there's the question of where is the performance to take place? Well, it used to be that pretty much everybody did everything in person, but is it going to take place over Zoom? And especially when you're doing employment or consulting agreements, you know, can the person work from home or do they need to come into your office? And as I mentioned, the question of what needs to be done should be specified. When and in what order must the responsibilities be performed? And for example, if you're developing a website and you just have a contract price, then the assumption is going to be made that you're not going to get paid until it's done. But if you're expecting to be paid up front, that should be said. Or if you need the client to answer a questionnaire or provide certain information first, then that should be stated. So both parties and anybody else who's looking at the contract should understand what is to be done in what order. And finally, I think it's also a good idea to mention what the purpose of the contract is, because this gives both the parties and anybody else who might be involved in enforcing the contract an idea of how to interpret the provisions in light of the purpose of the contract. So let's talk about some other very important provisions that should be included in your contract. One is the standards and methods for determining acceptable performance. I don't know whether any of you do business over Upwork, but I'm one of the arbitrators for Upwork. It's an online-based marketplace for people to provide consulting services. And disputes often arise because nobody has clearly defined the standard for what is acceptable performance. And when people are providing services, for example, such as development of a website, you know, you might not know what it's going to look like until it's done. But if you can, you should specify as much as you know about your expectations about what topics are going to be covered, what on the website, what technology is going to be used. And often you want to have a method so that the party performing the services doesn't perform all the way along and devote a lot of time and effort to it, and the other party is dissatisfied. So you probably want to have steps along the way where you get the buy-in of the customer that they approve what's been done. Other important topics have to do with allocation of intellectual property rights. People don't realize, for example, when they're having a website created, it's really important that you, as the customer, be the owner of the URL. But it's also extremely common that the party who's creating the website will register the URL and put it in their name. So you want to make sure that the parties are clear on who owns as intellectual property assets, such as the URL, the content of the website. if work is being done for you as by a consultant, that they assign the rights and the copyrights to you. You want to protect your trade secrets through non-disclosure, confidentiality, possibly non-solicitation, kinds of provisions. As I mentioned, often when people are providing services, they don't know exactly what's going to be done ahead of time. And this is called an incomplete contract. So you do need to have mechanisms for communication and decision-making. And you want to designate who is responsible for communicating on behalf of each party. And you want to, if this is going to be an ongoing collaboration, you might want to think about requiring regular status reports or weekly meetings. You might want to have a provision that says, you know, I'm going to give you notice, and if you don't object, I'm going to act on it in 3 days. And the method and address for providing notices also should be specified. Let me say this. Many lawyers and contracts people use and reuse contracts. One of the things that often does not get updated are notice provisions. Often you'll have a provision that says, notice is deemed given 3 days after a letter is put in the mail. In today's day, where we have email and faxes, there's no reason, and overnight delivery services, there is absolutely no reason for such a provision to be there for notice. So, another important area in contracting is risk management and allocation. So when people hire somebody or retain a company to provide services, they often make certain assumptions about them. But if those assumptions are important to you, you probably want to get them in place as representations and warranties. For example, in the website development agreement, you might want to represent that the company developing your website, that everything that they're going to provide to you is original or in the public domain and doesn't violate anybody else's copyrights. It happens quite often, for example, that website companies themselves don't understand intellectual property rights, and they might use a photo, the copyright to which belongs to a third party. And then the customer receives a cease and desist letter from the owner of the copyright demanding that the photo be removed. Other things you might want to think about are insurance, especially if there's something high risk going on, like construction. You might want to require indemnification for breach of those warranties, so that, for example, if somebody claims that anything that's on your website infringes their copyright, that the company that provided the website would indemnify you. And you also might want to think about a force majeure clause. We've all just gone through 2 horrible years of COVID. That's thrown a monkey wrench into a lot of contracts. Ask the people in the real estate business or the event planning business. And so you might want to think about what happens if a force majeure event such as COVID happens. Do you still have to pay for that event you put a deposit down on, or are you excused from paying? Do you have to pay your rent or not? And finally, a very important kind of provision is a dispute resolution provision, where you and the other party can decide how you're going to resolve things if a conflict arises. Now, of course, I'm going to have this bias, but I will say you want to at least have a mediation clause there, because mediation is a much less adversarial and expensive way to resolve disputes. It allows the parties the possibility of rectifying things and going forward together. And I would say for the process of getting decisions made on contracts as to who's right and not, you really might want to consider arbitration. I have to say it is much faster and convenient than the court system, which has tremendous backlogs, and it can take a very long time for disputes to get resolved. So let's talk about some red flag situations that I see in my, both as a lawyer and as a mediator and arbitrator, helping businesses and employers and employees resolve their conflicts. So one are incomplete or unclear contracts. You often see things with typos, which make the content unclear, missing dates, missing amounts, missing schedules. So when you are entering into a contract, you want to proofread it and make sure it's complete and that any exhibits or schedules are actually attached. One of my favorite things, let me say one other important provision that I neglected. I'm going to go back to the prior screen, and we talk about communication and decision making. One very important thing is the process for making changes in the contract, because the parties do often encounter the unexpected. So a mechanism for change orders should definitely be included as well. So let me go back to red flags. Internally inconsistent provisions. So often the parties will make a change to one provision and not consider the fact that newly changed provision is now inconsistent with other provisions in the agreement. Just as an example, they might negotiate the contract price. They lower the contract price, but they don't change the milestone payments. So somebody is looking at it and saying, you know, there doesn't seem to be agreement on the amount of that's supposed to be paid. Or did they anticipate changes to the milestone payments, but it's not reflected? Another one of my favorites is the battle of the forms. So you have one side sends the other a purchase order. The other side sends back some kind of acknowledgement, which on its face rejects any terms of the purchase order that are inconsistent with the acknowledgement. Then both the parties and a mediator or arbitrator have to determine what is the contract. You also have situations where somebody sends a contract. The other person responds, that price is too high. But then somehow the parties start performing. Has the party which objected to the price, are they bound to pay that price? Has there been agreement on the price or not? So basically, you want to avoid the battle of the forms or the exchange of emails and have what it is that the parties have actually agreed to in one place. Leslie, yes.
We have a question from Ross, and maybe you'll get to it later, maybe, but you're talking about specific little things in the contract, so this sounds good. And he'd like you to talk about available options for sample contracts, like MetLife Legal, Law Depot. I'm going to throw LegalZoom in there because we've had clients call and say terrible things about LegalZoom. So is this something you're going to talk about at the end or something you're going to do now?
I will talk about it right now.
Okay, thank you.
So, this is a really tough question because there are contracts available to the public online. I have, and some of them might be good, some of them not so good. And I do understand that when people are starting a business, that they don't want to spend a lot of money on attorneys. However, I think spending some money on an attorney to prepare the contracts that you're going to be using in your business is a good idea. Let me explain that there are services available to lawyers that are more expensive, that do provide template contracts, but they also have very detailed articles that lawyers can read on each of the contract terms, and they provide options for different situations. And they can be very helpful to lawyers in drafting agreements. So at the very least, if you're going to use a contract that you've gotten on LegalZoom or one of those other services, I would suggest having a lawyer review them with you. The other thing is, and I actually see this on a legal listserv that I'm on, people are always saying, can I see a standard distribution agreement? Well, I have news for you. I worked for a manufacturer for 15 years as in-house counsel. There is no such thing. There are so many variables in business arrangements that you need to make a decision about how you want to do business and have your contracts drafted to be consistent with that. So I hope I've answered your question. But just this week, I have a new client and she had gotten some contract off the internet and she sent it to me, and I spent probably more time fixing it than I would have had she consulted me in the first place to draft the contract for her business. And I think, like, would you have somebody who's not an architect prepare your blueprints? Probably not. And as lawyers, I mean, if you have a good lawyer, they're going to be conscious of your budget and not reinvent the wheel. And so, you know, I think it's a good investment. Let me also address one risk allocation topic I neglected to mention, which is warranties. If you're providing a good or service, the warranties that you make about it. All right, let me get back to our slide. We talked about battle of the forms, schedules and attachments. So do you have the right ones there? Are they actually attached? And often I see conflicts between the main agreement and the schedule. So usually there should be a provision saying in the event of a conflict, which one prevails, but conflicts between main agreements and schedules create confusion and conflict. The next item on our slide is poor alignment of incentives. I see this all the time where customers are asked to pay fully for a service up front, and then you do not have the party performing the service might not have an incentive to complete the job. So I'm a big fan of milestone payments. And even in the business partnership perspective, I feel that people should be paid for the value that they bring. You often find people saying, oh, let's divide everything up. There's 3 business partners, we'll divide it up 1/3, 1/3, 1/3. And then you find that one person is bringing in all the work and doing all the work. So, you know, I think you want to provide people rewards for fulfilling their obligations and also adverse consequences for not doing so. And finally, you often have situations where there are multiple parties involved in a situation. Construction is a typical example where you have the customer, you have a general contractor, and then you have a sub. And the contract between the customer and the contractor has a certain provision in there, but then there's a failure to include that in the subcontract with the relevant subcontractor. And so the subcontractor has not been contracted to provide the right performance, or often the contractor might make certain reps and warranties, but they're not included or repeated in the contract with the subcontractor. It's also the case as to dispute resolution provisions. You might have an arbitration clause in the construction contract between the party having the construction done and the general contractor, but it's not in the contract with the subcontractor. And then you end up with having disputes all related to the same situation, having to be resolved in multiple forums, and that increases costs, and it also increases the chance of inconsistent results. So you want to make sure that your general contract lines up with your subcontractor. And this could be the case also, for example, if as a customer you retain a company to build you a website and the web developer outsources part of the project. The web developer has represented to you as the customer that they're going to transfer all the intellectual property rights in the website to you, but they neglected to get the same representation from their subcontractor. Well, they can't transfer to you what they don't get from their own subcontractor. So all the contracts need to be looked at as one to make sure that they fit together well, like a good jigsaw puzzle. So at this point, I'd like to mention a couple of things and invite questions from the audience. Number one is that I do publish a newsletter every month called Making the Connection, which is devoted to legal and dispute resolution topics for businesses and employers. And if you are interested in subscribing, then you can contact me by email at lisa@lisapom.com, or go to my website where the current newsletter is posted and ask to subscribe. That also lists future speaking engagements. I pride myself on creating a community of the informed, and I really do love to speak to business audiences, and I'd love to see you guys at future events. And, you know, if you're interested in linking with me at LinkedIn, I'm also open to that. And now I'd like to take questions from the audience.
Okay. Anyone, something somebody made me aware of a couple of workshops ago. Some of you who are doing this on a cell phone or on a computer screen where you are full screen, you may not be able to see the chat. You may not be able to see the chat panel. And I'm typing things in here, so you may or may not see them. But I want you to know, first of all, that we will provide Lisa's contact info in the follow-up email that you'll receive before the close of business today. So if you can't copy and paste it or for your chat today, you will receive it before the close of business today. And we do have one question from JG. He says, we're a small business. We sell to large contractors like Boeing and Lockheed. Their POs have 8-point font on the back, on back their PO terms. They have such a monopoly power in our sector. It's like take it or leave it. Should he be concerned and pay a lawyer to review this, or just assume this is the risk of doing business with them? JG, would you please unmute and explain what you mean by 8-point font?
I get it completely.
Okay, never mind.
That's okay. Although I'd be happy to hear from JG, but I used to work for one of those large manufacturers, and we were not very interested in modifying our terms. However, I do think that if this contract is very important to your business, that you want to make sure, number one, that you understand it and the risks involved, and number two, and there's somebody on our call who could prove that, attest to this, that actually, even though they're 800-pound gorillas, that if you have a legitimate reason why you cannot agree to a particular term, or it's irrelevant to the contract, that you actually can persuade the contracts person or the legal department to change it. And I've done this on both sides of the equation, and it is doable. I mean, the part of the problem that happens in large organizations is they have standard contracts and they send them out. And honestly, they often don't jive well with the terms of the specific transaction. So I would say it depends on the size of the contract and the risk to you. You're saying that did not answer your question, JG, I'm sorry, would you like to clarify your question?
No, it says, but that did answer his question.
Oh,
Thank you.
that did. I'm
Yes.
sorry, I said that did. I saw the not above. Okay, I'm glad. Who else might have a question today?
Lisa, this is Bill. I've got a question. Recently, I came across the term, one of my clients was talking about piercing the corporate veil. What is that?
Okay, I'll explain that. You might recall that I talked about how important it was to identify who the true parties to the contract are. And the reason for that is if you do not keep close attention to the corporate formalities, have separate bank accounts, sign every document only in the corporation's name or the limited liability company, then a company can do what's called pierce the corporate veil. And if there's a claim against the company, they can go not only against the company, but against you individually. Right. That's why observing the corporate formalities is so important. I see somebody wants negative sleeper provisions. I'd be happy to talk about that. I just was dealing with that yesterday. So I have a client who provides interior design services. But this client is not involved in anything structural with the building or with doing construction. But nevertheless, when you have often the construction contracts that are put out to bid have provisions basically shifting all risk to anybody who's involved in the project, whether or not they actually are performing any services that create any risks. And sometimes it's possible to negotiate those and say there's no reason that my client should assume any liability for the construction related issues because she's not performing those services. But that's an example. And I have to say that lawyers, honestly, there's a lot of over lawyering going out there on there by including provisions that are terribly one-sided and unfair. And that's really a reason to have a lawyer involved to make sure that you're not taking on some risk you shouldn't. What should be included in a supplier agreement? Okay, so I worked for NEC for 15 years. We sold business telephone systems. So it's what is being provided, the products, what services that go with it. What's the term of it? What's the warranty? What are the reps and representations and warranties of both parties? Are there any legal requirements that are applicable to the goods or services that are going to be provided? Do you need to require, certifications of compliance with various federal laws, like limiting the export of technology, or as to how things are labeled? And it's really important if you're the customer in this situation, what is the time for performance? If you're ordering Christmas lights, you don't want to have them arrive in January, and is time of the essence. So really the issue is understanding what is important to you from a business perspective and making sure that your interests and concerns are reflected in the applicable contract provisions. Any other questions today?
I thought I was unmuted. What should be included in a supplier agreement and how often should it be renewed?
I think I just answered that one. And as far as the renewal, it depends. You know, agreements can be they can be open-ended. Oh, this is a great question, the next one that I'm going to ask. But as far as renewal, you can have automatic renewals. You can have it that both parties agree that it will be renewed. You usually want to give yourself an option to modify the contract at renewal because you're going to find out what's not working. So this is really a great question from Jeannie Byrne. What kind of provisions are necessary for a visit or assessment to develop a scope of work? Well, if you're the customer, you might want to have the prospective service provider sign a non-disclosure agreement because you don't want to have your confidential information that you might be disclosing so that they can do a needs assessment shared with anybody else. I also want to mention the possibility. Some companies, and I actually think it's a good idea, will break up the contract into different phases, and the first phase might be a needs assessment. And so you might want to have a separate contract to conduct a needs assessment, because a lot of times what happens is companies do a lot of work in the needs assessment only to find that the prospective customer basically takes the information out and gets quotes from a variety of suppliers. Leslie, I know we're we've been here in an hour. I'm willing.
Okay.
I'm willing to stay on for a few more minutes if people have questions.
Terrific, thank you.
And is it typical to be able to charge for a needs assessment? That really depends on your business model and what happens in your industry. But I think it's something that makes sense, especially if you're going to do a good job on it. So any other questions from anybody in the audience?
No, it doesn't seem to be anything.
I think there's one more.
Okay.
Oh, yes. Bob?
Yeah, hey guys. Very interesting when you're talking, Lisa, and I appreciate that. I think you had been in person, a couple of years back talking about, over at our SBDC center. Appreciated your insights on, agreements and such. We had an interesting case that we had placed a purchase order with a supplier. And what ended up happening is the supplier themselves actually went direct to our customer and started selling to them. And so we figured, all right, well, if they're going to do that, we're not going to pay for some of the purchased parts that we got from them. And we ended up going to federal court in Chicago. And essentially, what the other, VP and I were told is that, a purchase order is a contract, not taking into account other things that might have happened. And we ended up, having to pay the bill. Mm-hmm. And even though they had done something wrong and they violated a trust by going direct to our customer to start building and selling parts to them, it didn't matter. And the judge just said, you guys really work this out because you don't want to end up with a long federal court case.
Right, and that goes to the point that I made, is that you might want to think about having various provisions in your agreement to protect your intellectual property. And that might include non-solicitation or non-circumvention provisions and confidentiality, so that they can't use confidential information you're providing to them for their own purposes.
Yeah, we learned the hard way.
Mm,
But thank you so much for sharing.
yeah, thanks. That's bad. It's bad.
I don't think we have any more questions, do we, Leslie?
I don't see any. Bill, you can stop record, unless you have a follow-up, put your follow-up speech in here, and then you can stop recording.
Okay, great. Yeah, well, the only thing I have to, well, first of all, Lisa, thank you very much. This was
Yes.
extremely informative, a lot of detailed information, and I appreciate it a lot, and I know that our audience did. Also want to thank Leslie for being the person in the background kind of running all of this. And I've been asked again for any of the Stony Brook University faculty of staff, just to make an announcement about, if you're involved in research contracts conducted through the university, those contracts are now managed by the Office of Sponsored Programs. And if you need more information on that, you can go to and Google Stony Brook University Office of Sponsored Programs. And I think that's pretty much it from me.
Okay, I again want to thank the Stony Brook SBDC and the audience for being so interactive today. I love when people ask good questions. And again, if you're interested in subscribing to my newsletter, just send me an email at lisa@lisapom.com or connect with me on LinkedIn. It's been a pleasure being here this morning.